of law, the foundation of a free and fair society where access to justice is available to all. It underpins our Constitution and is what drives and unifies our 10,600 employees across 150 countries worldwide at LexisNexis. Enabling the way corporate, legal and government professionals do business, making it possible for them to shape the world we live in for a better future. A leading legal technology organization with more than 85 years' experience in the South African legal landscape, we empower legal practitioners with access to the latest precedents, expert curated content, and solutions to drive the wheels of justice in our country. Using artificial intelligence technologies such as data analytics, natural language processing, and machine learning, we are reshaping the way legal professionals work. We offer governance, risk, and compliance software solutions that assist corporate professionals in proactively identifying and managing areas that could potentially impact their business, and help human resource practitioners appoint the right people with the right qualifications to drive a profitable future. We play our part in making it possible for individuals to become the rightful owners of their first homes, bringing the property ecosystem together by harnessing the power of technology. We get it right so that our customers can get it right. We are advancing the practice of law, the compliance with law, and the upholding of the rule of law. Because at LexisNexis, we are advancing what's possible.
Good morning to all of you who have joined us for the webinar on the Protection of Personal Information Act, POPIA. My name is Ravona Naidu, and I'm the Operations Executive of LexisNexis South Africa. LexisNexis has a proud history of helping clients to advance the rule of law. In fact, our vision is to enhance the potential of the African continent by advancing the rule of law. And by that, we mean the practice of law, compliance with the law, and the upholding of the law. We ultimately want to help guide clients to better decisions that are grounded in the latest legislation and regulatory developments to ensure that we are protected against risk in the most robust way. This is why today's webinar is so important. POPIA has been in a work in progress since it was earmarked for implementation by the South African Law Reform Commission in 2005. The Act was originally tabled 12 years ago and signed into law in 2013. Yet very few of the provisions in the Act have been operational to date. It has come into force over a period of time with incremental implementation since April 2014. In many ways, South Africa has been playing catch up to the rest of the world in terms of the privacy laws. In its current form, POPIA commenced on 1 July 2020, and businesses were given 12 months to take the necessary steps and changes to become compliant. Even now, some of us are still grappling with what personal information actually covers. So what do we need to know about compliance by 1 July? What are the non-negotiables in terms of implementation? We have a special guest, Advocate Collen Weapond, a representative of the SA Information Regulator, on our program today. Welcome, Advocate Collen Weapond, and I now hand over to you.
Thank you so much. Good morning to everybody. I'd like to observe all protocol. I'm actually one of the members at the Information Regulator, and our primary duty is to ensure that we enforce compliance and also ensure enforcement of all the provisions of POPIA. And what is very important for us at this stage is to ensure that the regulator readies itself for the 1st of July 2021. That's now the period that we refer to as the post-grace period. The grace period that we actually have put as an automatic, if one can call it an automatic grace for 1 year to ensure that responsible parties ready themselves for the coming into effect of all the provisions, or actually the compliance and enforcement requirements, because POPIA is effective except for sections 110 and 1144. What is also very important for us to appreciate at this stage is to ensure that we look at all the guidance notes that have been issued by the information regulator. The guidance note that I refer to is, for instance, the guidance note on information officers, the guidance note, for instance, on COVID-19, the guidance note that we have on prior authorization. And there's a few other guidance notes that the information regulator is working on. One is on direct marketing in terms of section 69. Another guidance note would be on cross-border or cross-border transfer of personal information in terms of section 72. And that's very important for us to ensure that these guidance notes are released before the 1st of July 2021, so that we can track the necessary guidance for responsible parties to actually start to comply with the provisions of POPIA. The guidance notes are in no way a substitute for the provisions of POPIA. What the guidance notes seek to achieve is to provide solid guidance. I usually refer to that as soft guidance in order for responsible parties to appreciate the thinking and understanding of the regulator. And that's actually supporting, the guidance notes are actually supporting the regulations and also supporting the act per se. When one look at the regulations, certain regulations, if you would look at our website coming into effect, just look at regulation 4 and also regulation 5 with the different time periods, one for the 1st of March and one for the 1st of May. What is very important is also for us to appreciate how responsible parties will ready themselves. And one of the key steps that all responsible parties should take is to do a privacy impact assessment, what we call in South Africa as a personal information impact assessment. That would now form the basis for a responsible party to comply, but taking into account that whatever gaps and whatever analysis or the outcome of the analysis will then result in what we would call a compliance framework in terms of the regulations, actually looking at section 55, which then resulted in regulations being created. What is also very important for us to appreciate at this stage is that regulation, if you look at section 112(2)(c), which refers to a regulation concerning health. That specific regulation has not been developed, and it was purposefully so that the regulator can consult with various stakeholders in the health sector in terms of section 32(6), and section 32(6) will take us to section 1B and 1F, which requires for us to consult, especially with the Council for Medical Schemes and also with the pension funds sectors. And that's very important for us to appreciate, because one of the key steps that we want to actually unlock is to ensure that the health community, as directed by section 32(6), with reference to 1B and 1F, is properly consulted, and also that we have the same understanding about the technicalities and also the complexities of the health sector. When we embarked on a benchmarking exercise a few years back, we focused on Canada, the one group, and the second group focused on Germany and the UK. And we have picked up a lot of key issues. The key issues that I'm referring to is that when we look and appreciate at the guidelines that has been issued on the development of codes of conduct, there were two key stakeholders which are very complex and also very large, and that is your telecommunications and your health sectors. And those two sectors are the sectors that will also, ensure, that they enjoy priority in terms of obtaining their codes, or approved codes. What we also looked at is section 60, that refers to functional equivalence. Functional equivalence, when we look at our code of conduct, is actually a standard that is the equivalent or higher than the one that cannot be complied with due to the specific features of a specific sector. And that's very important for us to appreciate and understand what drives the regulator to consider and to have actually ensure that a regulator has developed guidelines on the development of code of conduct was actually section 41F Roman figure 2, which then directs the regulator to ensure that guidelines are developed. And what is also very important to appreciate at this stage is that the regulator has also ensured that it secures the necessary human resources and capacity to be able to operate. A lot of questions have been circulating around the portal and when will registration be open for information officers. When I refer to information officers, we refer to both information officers authorized as acting information officers, as well as deputy information officers. So what is very important for us to appreciate is that the portal will definitely be opened during the month of May, and the portal will then be directing responsible parties to register their information officers with the information regulator. What is also very critical and key to understand at this stage with regards to multinational companies, those are companies that operate across various countries. It is just for us to ensure that there must be a deputy information officer in South Africa whom we can consult and make contact with. You would know the complexities of the structures of multinationals like Amazon, like Facebook and Google, etc. And that becomes very important for the regulator to have a point of contact. What is also very important to understand and appreciate is that a regulator has definitely looked at the whole arrangements around information officers. And what the regulator is saying is that it is upon all responsible parties to analyze their specific processes on which they process personal information, the size of the organization, and what you need to take into account is that a deputy information officer is actually required if your organization is structured and quite large also, or medium to large, so that you can be accessible to the public, especially with regards to putting an objection forward, and also to ensure that you are actually processing personal information in line with the provisions and the requirements of POPIA. What is also very important for us to appreciate is
Collen,
that,
apologies.
yes.
I raised my hand and was waiting for an opportunity to jump in. I'm sorry that I have a question so early on in the presentation. With regards to your references of codes of conduct being developed and two particular sectors, health and telecoms, having been identified as specialist sectors, what is the position with regards to the private security industry?
The private security industry is another industry that falls within, a specific sector. That should basically you should, for instance, look at your sector. You'd understand the dynamics, and then also use the application route. But what is very important to do is to ensure that there is a consultation. And what the Act requires is sufficient representation of that specific sector. So basically, there's a lot of sectors, but the two sectors that we have definitely looked at is the health and definitely the telecommunication, because of its complexities and also the size of those sectors. But the security sector is like any other sector that that can also apply for a code. We've just prioritized and looked at, and that's the results that the benchmarking is actually provided to us. That these two sectors usually requires prioritization in some shape and form, but also to ensure that they do have codes. Thank you. Should I continue to round off?
Yes, please, Collen.
Thank you. So what is also very important for us in closure is basically just to ensure that we ourselves as the information regulator remains accessible, and also for the fact that the regulator must actually not provide advice, legal advice, but definitely guidance, because it could, to a certain extent, be a conflict of interest where we have to now provide or regulate the type of advice that we've given. So responsible parties are encouraged to seek their own advice and to actually continue to implement the provisions of POPIA so that they can comply come the 1st of July 2021. I'm just going to stop there in the interest of time and then also hand over to our facilitator. Thank you.
Thank you, Advocate Collen. We really appreciate the time you took this morning to share with us. All answers to any questions that may have been sent through for Advocate Collen will be shared with you after today's session. We are very pleased to have with us today Ahmore Burger-Smidt, who has been a regular expert on various LexisNexis POPIA webinars. She will share with us the focus areas for compliance by the deadline and an expert opinion on the additional commentary and guidance as released by the Information Regulator. Ahmore Burger-Smidt needs no introduction, but in a nutshell, she is the Director of Werkmens Advisory and the head of the Data Protection and Privacy Practice Group, and is well renowned for her expertise on data privacy. She extensively advises local and international clients on all aspects of regulatory compliance, with specific focus on competition law and data privacy in various sectors. Ahmore is a regular speaker and participant at local and international conferences and seminars on competition law and data privacy. She is a member of the International Association of Data Privacy Professionals and is currently studying towards a LLD, Data Protection. Ahmore is also the co-author of the textbook, A Commentary on the Protection of Personal Information Act, LexisNexis. Ahmore, welcome, and over to you.
Morning, everyone, and thank you for joining us. I might say we are living in interesting times, and the first example of that is, despite the fact that we're in the midst of the COVID era, we are indeed fortunate and blessed that Advocate Vipon joined us this morning, despite the fact that he's attending currently to a family funeral. So we appreciate his attendance and sharing some thoughts with us, and that's part of the reason why we had to change the program. Together with that, I didn't think I'm going to host 500 plus people in my home this morning, but due to COVID regulations, at the moment, I'm not allowed to go to the office. So welcome to my inner sanctum, my study, where I spend most of my time, if not in the office. So I've noted, and I think it's appropriate for me to just first deal with some of the questions that I saw coming up while Collen was speaking. And one of the first questions that was posed, Brian asked that, whether there are minimum aspects from a POPIA perspective, if we look at SMMEs, the SME sector. Now, I'm sorry to say there isn't any of that. The SME sector as such is not at all, can I please share my own screen? I'm about to do it, and I'd prefer if I do it, thank you. So just seems like we've got, right, I'll share the screen now so no one thinks we don't have a presentation. Unfortunately, just ran over. So as I was trying to say, if we look at the SME sector as such, there are no specific exclusions for smaller businesses. So the South African legislation was formulated to apply to all businesses, no matter the size, no matter the number of employees. And that also runs through, if we consider the concept of an information officer that needs to be appointed. In Europe, there's a different system, but here we are looking at the right to privacy applying across the board to all businesses, to all individuals in the country, irrespective of the size of the business. And I think, and I'd like to suggest that that was part of the reason why LexisNexis also thought it's appropriate to have this webinar this morning, just to discuss while we running in this last sprint to the 1st of July to try and pull together some thoughts around what compliance with POPIA requires and what we need to get in place. We've been talking about this for a very, very long time, and we know one thing, that if we look at POPIA compliance, in a sense, it forms a strategic framework within your organization, within your business, to manage the information, the personal information you have. In a way, and this is very important, personal information ought to be managed in a way that maximizes value while minimizing the risk for regulatory mishap to take place, for contravention to take place, and for non-compliance with the legislation. There's immense value in personal information, and we'll go into a bit of more detail around that. But, earlier this morning when I read through the presentation, I looked at it and I looked at my conclusion slide, and it did look a bit different, but I amended it and I thought it's appropriate this morning to start with this conclusion. Because if we look at the environment we operate in and we look at operational complexities that we're dealing with, we've got evolving business needs, we've got consumer expectations around how we deal ethically with information. This data explosion that we are experiencing is enormous, the amount of information and where it flows and how it interacts. And if we look at global evolving data privacy legislation, South Africa is not unique at all. And we are not operating in a vacuum at all. So if we consider where we are today in the world we live in, we need to know data is growing, data breaches are soaring, business needs are exploding. And in all of this, we need to comply with the POPI legislation. At the same time, we've got security that we need to consider and how we're going to deal with this security. We don't only have hard copy files. We've got data in the cloud. We've got various databases that one can think about. We live in a virtual environment. It's archiving, it's applications and web service and file service. So yes, the environment is complicated, and often we don't think about it. Often we think data privacy and keeping the personal information secure is someone else's problem. And that is a fallacy. So what are the minimum things? What are we supposed to look at and think about if we talk about compliance with POPIA now, immediately, and the way forward? So it's a new landscape. We've got more data, it flows faster, it flows further throughout everyday business that we are conducting and what we're doing. And we need to be conscious about how we're dealing with this. If we look at, on your screen, the explosive nature of data growth, this is a double-edged sword, because on the one hand, data is enabling our businesses. At the same time, it's such a disruptive force. We need to create competitive advantage, and without information, we cannot function in a vacuum. We need data in order to be more successful and to actually achieve the outcomes we strive towards. Now, on the other hand, we have to deal with not only growing amounts of personal information, but to understand what is special personal information, because POPIA deals with that in a carve-out manner, and there are additional duties in relation to special personal information. So more than ever before, we need to realize, what are we actually talking about? What are we looking at? What are we supposed to protect? What are we supposed to govern on a day-to-day basis? And it is a complicated challenge sometimes. What I've come to realize is that often we don't think about the personal information that we need operationally and that we deal with. And then the issue that, the speed with which this information can move on a daily basis. It's not only the volume of the personal information, the data that we deal with. It's also how quickly it can be sent out, terabytes, megabytes of data, that it can spread between business units or divisions or departments within a company. It can spread outside of a company so easily. And the question then centers around, but how do you secure the quality of the information, a core requirement of the data privacy legislation? And, for what purpose are you sharing? For what purpose are you sharing this information between departments or with other organizations? Then where's it actually going to? Because if we look at the conditions of POPIA, in terms of accountability and in terms of openness, in terms of data subject rights, these are all fundamental pillars of POPIA. And if we don't understand the fact that data grows and that it moves at a speed that we've never anticipated, we can't actually understand and apply the principles of the legislation. And that this in itself, unfortunately, creates enormous levels of risk for each and every single company. If we look at data privacy, it must be thought about as an important aspect, that it must become part of the DNA of any organization, of any company, how we deal with data and how we protect data. It can't stand in isolation, and we must apply it, and we must apply the principles throughout the company. Otherwise, somewhere we're going to lose the chain that binds all of this together, that enables us to comply with data privacy legislation. So it is across the company, it's across the enterprise that data privacy legislation applies. And in fact, it involves everyone within the company. This is not something that we park off at the person responsible for legal or the person responsible for the IT function. Data is managed, personal information. It flows throughout a company, and it is everyone in the company's responsibility. Therefore, if you look at one of the functions of an information regulator, it's actually to train everyone to understand what personal information, this personal data entails, and how one should deal with it. So if we look at the DNA of an organization, that a privacy regulation ought to flow through, and that it ought to be an enterprise-wide initiative, and that it involves everyone. We need to remind ourselves, if we look at personal information, that is a catch-all term for any form of personal information within a company. So just from a GDPR perspective, and we've analyzed that, in terms of the GDPR, they've named 60 elements that meet the criteria of personal information. Now, if we look at the South African legislation, and there are great similarities between the South African legislation and the GDPR, the reality is that there ought to be at least 60 elements that qualify as personal information from a South African perspective as well. So we live in a new paradigm. We've changed, the world has changed around us. We don't live in a world where we've got traditionally structured data. We live in a world where we want to analyze the data because we want to derive value out of the information, while at the same time, customers demand ethical use of the information, the personal information we've got control over. And while we know as companies, we need to keep personal information secure and handle and deal with it in a particular manner that as a lawful basis for us using the information, and that we must as companies protect the information. At the same time, we've got what we call threat actors, those people that want to gain access to our inner sanctum, and in fact gain access to the information. The information regulator earlier this morning mentioned health information. Now, health information worldwide happens to be the most valuable personal information on the dark web. People sell this information. So if that's the most valuable information, and the sophistication of attacks on the health sector, it highlights the importance of complying with not only POPI legislation, but also complying with the relevant cyber legislation if we consider the protection of personal information, because it can have an immediate threat and impact on each and every single individual. And then I've mentioned earlier that there's an enormous explosion in data privacy regulators all over the world. Long gone are the days where it was only Europe and Australia that had information regulators. In fact, most of the world we operate in nowadays do have information regulators that we need to comply with legislation with. So we've reached a point of almost a perfect storm if we consider it from a data privacy perspective, because we've got an enormous amount of personal information. At the same time, data loss is always a problem, and it impacts not only from a regulatory perspective. If we look at the research that was concluded last year, 96% of global consumers indicated in surveys that they will boycott companies that experience a data breach, that don't protect their personal information. In fact, in surveys, 62% of individuals blamed the company for the hack taking place and not the hackers. Looking at this as we need to provide as companies this absolute security. Now we know one thing, the Protection of Personal Information Act does not require perfection. It requires of us to put reasonable measures in place to comply with the legislation and to keep the information, the personal information that we hold secure. Now, if that is the legal test for each and every single company, isn't it strange that as individuals looking at our own personal information, we actually expect something perfect from businesses? But for a business, that sends out and signals a very, very important message. What we also see through research, the moment there's an impact, a negative aspect around data privacy and how companies handle and deal with data privacy, that 83% of consumers will stop spending for quite an extended period of time. If we don't have customers to sell to, we don't have a business. And then also a worrying trend that we pick up is that 20% of consumers will never return to a company. So if we look at this spike in breaches and we look at consumer reactions there too, and we look at creating this environment that's all about compliance and thinking about compliance only, we need to realize it's not only compliance, but it's actually a business imperative that we will comply with data privacy legislation. So against that background, what does it mean? Let me just see how much time I've got left. Okay, no, we could. So if we look at the challenges of sustaining privacy governance, and we look at privacy governance as such, we do realize that there are certain things that we need to keep on our screen, and that is whether we top 100 entity on the JSE or whether we in SMME. The four aspects depicted on the screen applies to every single organization, no matter who or what we are, what size we are. Number one, our data is everywhere. It is not locked away in a file cabinet. It is hidden in silos and business silos. It's hidden in different departments. And it's crept in the way we've grown outside of the traditional parameters of, due to the fact that we make use of cloud storage. We don't have a server in a storeroom anymore. We use cloud service providers like Amazon. We've got third-party service providers that we use. We use software as a service applications. So number one, the personal information we deal with is not necessarily contained to an office and to a desk. It has filtered in a very big environment. And we need to ask ourselves, do we understand what that means? So this is indeed a challenge if we look at governance from a POPIA perspective and compliance with POPIA. Do we know what we have and where it is? Then the second aspect, if we look at a challenge for sustainability of governance, is that our personal information is being used in new ways. We don't live 100 years back. We live in an era where we've got artificial intelligence, where we've got machine learning, where we've got data analytics. And data analytics is driven by the desire to reap the value out of the personal information we have. I note that the questions are going up. We'll deal with it. We'll have enough time to go through the questions. So keep on posting. We'll come back to those if you don't mind. So if we look at data being used in new ways, we need to understand that new functions are developing, and that if we look at how people use the information, understanding it, mining it, wanting to use it to roll out new products, solutions to the customer base, we've got new ways of data use. And we need to, if we think back at POPIA and what the POPIA legislation requires, understand whether we've got a lawful basis, or what is the lawful basis for us using that personal information. Now, a worrying trend that we've identified is that companies and organizations tend to list consent next to everything. And I don't know whether I will call it an inherent desire, or whether it's actually an easy out that companies try to install, to just say, as long as I've got consent, everything will be fine. I can process the information. Yes, it's true. Consent is important. It's important to have consent in order to process the personal information. But at the same time, consent becomes a very dangerous basis, lawful basis for processing to rely on. Why am I saying this? Because the reality is consent can be withdrawn within seconds. And the minute a data subject withdraws his consent and says, I do not want you to process my personal information further, you are left with no option but to stop the processing of that personal information. Now think about it. If you go through an analysis process, and we'll get into a 6-step process just now, thinking about what compliance requires from you and how you work towards compliance with the legislation, and understand your data processes, your personal information flow throughout your company, you need to identify and think about whether there isn't a legitimate interest basis, lawful basis for you processing the information. If I talk about processing, using the information, working with it in the specific company. So what are we talking about? What are we thinking about? Data is being used in new ways. We need to be able to defend and put forward a lawful basis for processing. And consent is not always the easy way out to say, yes, I've got consent, because the moment that consent falls away, you need to suddenly find an alternative basis. So rather think proactively about the basis for processing the personal information. And that would be my sincere view and guidance to you. Then the second thing is data is growing. Your data is growing. If we look at again, statistics, large organizations, and if we look at it on a daily basis, it's estimated that some large organizations handle a petabyte of data and maybe even a terabyte of data on a daily basis. And I'm talking about data because we live in an electronic era. Yes, we still have hard copies, but a lot of us try to live in a responsible way, not print reams of paper anymore. So it enabled, our environment enabled us to just collate so much more information on a daily basis. So it's exploding. If you think the information you've got available just on the device used to join this webinar today, it's enormous. And do we actually understand that? And then the challenge that the data is accelerating. It is so much easier to share massive quantities of information at the click of a button. That also highlights the importance or the risk that we are confronted with as companies by mistakes that our employees make in terms of sharing personal information. So if we look at this whole environment, we've got personal information. We need to understand what that personal information is. And then I spoke to someone in my team and I said to him, what do you think at the moment is one of the most important things that we need to tell people during the webinar? And he raised the aspect that maybe people should consider not only what are the 6 steps to think about compliance, but to think about the immediate steps. And I'll come back to that when we speak. One of the questions asks about the guidelines and the concept of prior authorization, because that becomes an action point on your roadmap over the next two months. So, what are the 6 steps that I can put forward this morning to all of you if we think about compliance with POPIA and becoming more compliant and thinking about the risk and privacy that we deal with on a daily basis? Let's make absolutely no mistake. Delivering of an effective data privacy program can be complicated. It can be challenging, but it is definitely not unsurmountable. It is how we approach it in a logic way and manner. And with the right people and focus and process, we can address the problems in inverted commas, from the challenges from a legal perspective that we are confronted with. So for this morning's session, I tried to break it down in 6 steps for everyone to think about how do we actually prepare ourselves to become compliant with the legislation. And it's actually not only what do we put in place to prepare ourselves to become compliant. These 6 steps apply no matter where we are today or a year down the line or 10 years down the line, because compliance is never a single initiative that we undertake and then we step away from it. So we need to, on a continuous basis, think about how do we comply with the legislation and what do we do. So I've put out, and I thought the first point is define policies and rules. The reality is we need to understand the purpose. Why do we have personal information? How do we use the personal information? And what systems does it feed into? And what are the people-related issues around the processing? And what is the lawful basis for processing the personal information? And then special personal information, because we do have that category. So number one, just stop, identify what we are dealing with, because that will help. If we've got an understanding, will help us to build privacy policies and assign accountability and put the rules in place. Because without necessary rules and processes, compliance with data privacy legislation will inevitably be extremely, extremely difficult. We need to apply the rules. Another trend that we've identified, if we talk about defined policies and defined rules and put the necessary accountability structure in place, we've noted that a lot of companies currently in South Africa try and implement extremely generic privacy policies. Now, I question whether those meet the test from a POPIA perspective. If you want to implement a piece of text that repeat the legislation, to what extent are you actually meeting the requirements as set out in the legislation to be accountable and to be open and to afford the data subject their rights and to demonstrate the lawful basis for processing? If you've got a generic text reflecting or mirroring POPIA to the outside world, those policies, in my view, is a clear indication that companies have actually never gone to the effort to stop, to unpack, to understand the purpose and the use of personal information, what personal information, what systems they have in place, what processing of personal information takes place within the organization. So number one, stop. Think about what you have, why you have it, and what you're doing with it. And that then links directly to rules and responsibilities and policies, because in your policy, you need to explain to a data subject, why do you require certain information from him or her, what you intend to do with it, and on what lawful basis you will be using that information. And again, I reiterate, think about consent. If consent is the only basis that you rely on to use personal information, the moment that consent gets withdrawn, you are absolutely, in terms of the legislation, prohibited from processing that information. So it's not only the initial uptake of the information. I open a profile on an app. That is processing, and I provide personal information for that specific purpose. So we know you can identify in terms of the defined policies and rules for that specific aspect. The next question would be, so what if you now want to use that information for completely something different than the original reason why I provided my personal information to you? You need a lawful basis for processing and further processing that information. Again, you need to stop to think about what do you do with information. And I've said it a couple of slides back when we spoke about the DNA, and that is an enterprise-wide aspect. You can't do this in isolation. It calls for everyone in a company to actually think about what they are doing with personal information. Then the question of discover and classify. We know personal information are all over a company. It's the employees' personal information. It's our customers and suppliers' personal information. And different people do different things with personal information. And often we don't know exactly where it sits and what's being done with it. So we need to discover all those areas where the personal information is being held. And in addition to that, personal information often gets transferred from one department to another, from your company to a service provider. Do you understand that? Have you ever thought about the implications from a POPIA perspective of moving this personal information? I'll move along rapidly. Then you need to map identities. You need to identify the core personal information, because you get confidential information, but we're talking about personal information. So you need to map that. You need to understand it, where it lies, what it is, what is holistically linked to individuals that qualifies as personal information, because that will allow you to address the requirements in the legislation around data subject access rights, breach notification requirements. There are certain tick boxes that you need to be able to say, yes, I've done this. Yes, I've considered this. Yes, I've got a process in place for the following. A breach notification happens to be one of those. What have you got in place? Have you thought about this? How will you allow a data subject access to his information? Remember, a data subject can ask of you to correct his information, to delete his information, or just for you to tell him what information you hold about him. Can you do that? Have you thought about a process to implement that? These are things you need to be able to assess. Then analyze the risk. We know we've got a physical risk. There can be, God forbid, a fire or a flood, but there can be a cyber attack. So have we thought about how will we deal with each of these situations? And then protect and respond. Protect and respond, access controls. Where are we storing the information? How are we keeping it safe? Think about that. Are we encrypting information? Is there a process to anonymize information? If we send information to another country, personal information or data, or if we send it to a service provider, is it encrypted? What are the security processes we've got in place in relation to that? Is it sent as private information? Or can anyone hack it in this chain while it moves on to the service provider? These are things you need to stop and think about. And then we need to measure and report. We need to measure and report on a continuous basis. So at the end of the day, if we look at compliance and we look at putting together an effective data privacy program, the first thing, you can never do it if you haven't stopped and you haven't analyzed and you haven't actually mapped out, put on a canvas what personal information you are dealing with and for what purpose. That is the core aspect that you need to address. So what can I put forward to you to say that you need something to guide your thinking? You can't do this in isolation. How do you do it? We know that from a data privacy perspective, it is very important to delete information and to move information and to amend information in line with customer demands, because our customers, our data subjects have got more and more rights in terms of the data privacy legislation. And we'll also have to honor their request, the customer request to stop processing the information, they withdraw their consent, and how will we deal with this? And we can't do this without actually unpacking and understanding, you know, exactly what the impact is on what we do on a daily basis. So let's think about how do we guide our thinking, because, you know, if you need to put together a framework that will work uniquely for your business, there ought to be a couple of questions that should guide your thinking. Number one, what type of data are you using and for what purpose? Secondly, what is the legislation that regulates the use of your information? Because it's not only the protection of personal information, there are other pieces of legislation as well that impacts on how you deal with information. And then, you know, who are the owners of this personal information within your company from a business and a technical perspective? And how frequently will you access personal information? And what are the access control rules around this? You know, the reality is, I don't think anyone in an organization, in a company, will be able to answer these questions on his own. So it is important to reach out to get the collective thinking within the company and to conduct discussions, interviews, to find out exactly where this data flow, this personal information data flow, where it runs and where it is. Now, the reality is we need to understand where personal information is held, how it flows, where it travels, how it's protected. And that will help us to, if we think about it and we map it out, to understand exactly where personal information is located and how it is linked across the company. Why do we need it? What's the reason different business units need the information? What are the potential risks of a breach? Because I mentioned to you that a data breach notification is a core focus area that you should think about. And you need to assess, if you understand what personal information you have, where it's located, who's got access to it, and what's the potential risk of loss of this information. To what extent are you ready to deal with this POPIA legislation? And have you actually aligned your resources correctly to think about what POPIA entails and what you should be doing? So at the end of the day, it's not only about compliance. Compliance is very important because there are the administrative penalties and everything, but it's also about the expectation of your customer base. And you need to balance this. And this is the yin and the yang of the world we live in and where we operate, and especially from a data privacy perspective. You know, often I read and I think and I listen to things, and I think people seem to be under the impression that there's an absolute right to privacy. No, there's no absolute right to privacy. But if you as business do not protect the privacy, the reality is that you will be blamed for it by your customer base. And that is a problem. That therefore it is a business imperative to comply with the legislation. So my core message to you this morning, after LexisNexis asked me to talk about compliance specifically, discover, protect, control. These are the core aspects you need to focus on, because operationally the world we live in is complex, and you need to think about this. You need to be ready for ever evolving privacy landscape and how you're going to deal with this. And the only way you'll be able to deal with it is to discover, to protect, and to control. Thank you very much, Ravona.
Thank you, Ahmore. I just want to say thank you to Ahmore and Advocate Collen for such an insightful discussion on a very important topic for us. We did run out of time in terms of answering some of the questions. A question and answer sheet will be circulated after today's session. To all our attendees, we have some exciting special offers. Our practical guidance solution offers you practical content on how to apply POPIA in your organization. For today only, you can receive a discount of 25%. In addition, we also have a 20% discount on our print title that's available on the e-store, a commentary on POPIA, which is co-authored by Ahmore. After the session, please look out for a communication that will be sent out with discount codes. And please, can you also complete the poll that is now available on your screens? Once again, thank you all very much.
Ravona, am I wrong that we've still got 3 minutes left?
Sorry, Ahmore, you are right. You are right.
Can we maybe, while we've got 3 minutes left, if I can just, in a high level, quickly deal with a couple of the questions that came up, because I think that is just important to address that. Can I just say, remember, the South African legislation does not exclude any specific size of company, as I indicated right at the beginning. So we've got no exclusions to the applicability of the legislation. As long as you process personal information in South Africa, you domiciled in South Africa, you process the personal information, or you make use of systems to process personal information in South Africa, the legislation applies. So you can't carve out your responsibilities and say, but I'm not the right size. So remember, we all need to comply with the legislation. It is, what is the right size for your company and your size company? And in a sense, almost, if you step back and try and look at it logically, the size of your business ought to, in a large extent, inform the extent of the information you deal with, or what your core focus areas should inform that. So there are no exemptions. If we look at the appointment of a data information officer, or in Europe, it's called a DPO, so you'll often hear people use the terms interchangeably. In South Africa, our system differs from that in Europe. Because in the European environment, provision has been made that the DPO function, that information officer function, can be outsourced to an external party. If you read the guidelines, in 2 places in the guidelines are very clear that the information officer, or then the DPO, must be an employee of the company. So in South Africa, you can't just outsource this function. You need to prepare yourself. And that information officer or DPO must be your CEO, MD, or a person similar position and responsibility in the South African scenario. So Anya, if you ask the question, if you need a DPO, no matter of size, can we hire an external DPO? No, you can't. That must be something that will be an addendum to an existing employee contract, and it would become an additional functional responsibility. And in massive, bigger organizations, yes, this will become a full-time position. And I think, Isara, that answered your question as well. It can be an add-on duty or responsibility, or then a new position. And the focus on information officers, or then DPOs, is so central, because that person will pull together your compliance, POPIA compliance framework, and all the duties and responsibilities, if we look at this from a POPIA perspective. So understanding the role and duties of that person is very, very important. And if we are a group of companies, we can make use of deputies, and those provisions have been made. So our legislation is actually, in the guidelines, fairly robust and flexible if we look at that. So yeah, we are in a different world. We live in a new era, and we'll have to deal with all the questions then and come back to you at a later stage. But I trust that, to a limited extent, there was something interesting for you to hear this morning, and that I wish you well in the next 2 months with your POPI implementation processes. And then we look forward to hosting you on the next webinar. And yes, IP addresses are personal information.
Thank you, Ahmore. Thank you, everybody. Thank you for spending the morning with us. Keep safe and have a great day ahead.